All right, folks. Happy Friday. Happy Friday to you. I apologize for the technical issues that we were having, but I am back. I wanted to do a follow-up video from yesterday's show where, without a crystal ball, I want to say that she was the first person to expose the fact that there was the sham lawsuit floating around out there in New York. People have been wondering about this mysterious subpoena that was issued to Stephanie Jones that was used to secure foundational evidence that became the subject matter of a new lawsuit for Blake Lively. And I know that you guys have heard probably a bunch of lawyers talk about it today. I talked about it last night with my friend Lauren Knighty. And I think that the central question is, now that it's been exposed as basically being sham litigation, I was on live yesterday just going over the contents of the lawsuit with my friend Lauren. I was like, I don't think I've ever in my life seen a lawsuit that was written without a named defendant. Yeah, Doe's 1 through 10, sure, whatever. But that's usually in connection with a named defendant. And then, like, the contents of the lawsuit itself are weird. It was really unclear what they were saying, and then they attached to it. They filed it in New York. I guess strategically, because there's a 20-day waiting period once you file a lawsuit in California to issue subpoenas. In New York, it's right away. And they filed this lawsuit in New York. They issue the subpoena to Stephanie Jones. They get all kinds of communication, text message communications or whatnot, and then they just dismiss the lawsuit. And then they come out and say, Ezra, the beloved Ezra over there on Lively's side says, oh, people do this all the time. It's pretty common that you would use a Doe or an unnamed defendant's lawsuit for the purpose of conducting pretrial litigation, which is, I don't know. I've been practicing for 11 years. I've seen other attorneys weigh in on this case that have been practicing a lot longer than I. I've literally never seen it in practice. Neither have, I don't think I've seen another attorney corroborate this idea that's a common thing to just issue a lawsuit without a named defendant. It's just not a thing. What's up, Lauren? So obviously, big red flag. And then they just voluntarily dismiss it. And then the question becomes, well, one of the things that I openly stated last night when I was reading it, when I was literally, like, you saw my reaction in real time. I was like, what is the point of this? Like, who would you even serve? Which is specifically the point. Because if there's not any named defendants in the lawsuit, then you don't have to give notice to anybody that the subpoena exists. And to the extent that they were asking for the entirety of phone communications from Stephanie Jones and her employees, the objection would have been that, hey, this discovery request is overly broad. And so you would have objected to the subpoena. And then in the process of objecting to the subpoena, it would have had the effect of staying the subpoena. And then we would have figured it out all in court, and it would have been whittled down to, you're not going to get the whole cell phone. You're going to get, what is it that you're looking for? Do you want text messages? From what period? From what year to what year? What specifically is it that you're arguing? Because from the contents of that sham lawsuit out of New York, I couldn't make heads or tails of who they were trying to sue or what it was about. And so Sarah Dawn says, oh, it's my favorite game. Try to get Omar's attention while he's streaming. I've won this game before, and it appears you have won it again. Although when you're trying to get my attention, there's usually some kind of a thing. Oh, let Anita in. Hey, Anita, I sent you a link. Or maybe I didn't. Let me send you a link. I invited Anita because I can't take credit for the theory that I'm going to try to make sense of for you guys. Because she was at the forefront. She brought this to my attention. And then at the time when she first brought it to my attention, I was like, yeah, that's interesting, but I mean, hard to prove this and that, whatever. I don't really think that, by the way, Anita, link is sent. I don't think that too many attorneys have caught on to the fact that, hey, like, if you just connect the dots, you can make sense of it. And why is it important? Because I think that if you start just looking at it, the way that Anita has framed it, it's one thing to say, oh, she's Redditor, sleuther, whatever. But hey, the things that she said in her PDF that I dropped on my show a few weeks ago now, maybe 4 weeks ago, is all starting to come to fruition. What's up, Anita?
Hello. Hi. All good. How are you?
I just, I texted you, I don't know, 20 minutes ago to let you know I'm going live with this theory. But the more I'm thinking about this case, the more your theory is making sense to me. Maybe not in the exact way that you framed it initially. And you've told me that you've like kind of done some more work on it and like you're trimming down kind of the excess. But here is what I see. And look, this is a big deal because 47.1. I don't think that other attorneys are necessarily on board just yet because they view 47.1 as specifically protecting communications related to allegations of SH. And it's really hard to say malice of some other thing that doesn't involve directly SH is going to rule the day in defeating 47.1. I'm really starting to disagree. Here's what it got. And what I have is really born out of your theory. So
I'm
August 21st.
So proud of myself right now.
Well, you should.
Believe I made it. I've made it. I'm convinced you.
It's a good theory. I mean, it fits. It's like the way that things are playing out, it fits. So August 21st, 2024, Stephanie Jones confiscates the phone belonging to Jennifer Abel. That contains all kinds of private communications involving Baldoni's team. I don't know how they did it. They cornered her in the office, said, give up your phone. She gave up the phone. And she just held on to it. In September of 2024, we get this Sham lawsuit naming only Doe defendants. There's not really a genuine legal pursuit that I can really make heads or tails of. And they have a case number. They use that case number to attach to it this subpoena that's issued around, I think it was in October. They serve Stephanie Jones with this subpoena. Now, whether or not she showed that subpoena to an attorney, a company attorney, somebody, I got to think that she didn't. Because and nobody's really seen it. I've heard that it exists. I've heard that people are being really secretive of what the contents of the actual subpoena were. But I have to imagine that subpoena was asking for the entire contents, the entire communications of her and her employees, text messages, all of this stuff, right?
Can I interject just for a second here?
Of course. I think I know where you're going to go.
I'm just going to fill in that thing, just like if she had shown to her attorney. As a matter of fact, on her lawsuit, which she filed on the 24th of December, the lawyer who has signed off on her lawsuit is Ari Emanuel's brother, who is the guy who fired. Can you hear me?
Yes, I could hear you.
Yeah. So is the guy who fired Baldoni from the thing. So I think they were all in on it, and that's one of the links as well. But I just found that link anyway.
Well, the whole point is that whether or not she showed it to any attorney, nobody objected, and nobody would have had notice of it except for her. So, like, when you have named defendants and you want to issue a subpoena, everybody gets notice that you're issuing a subpoena. So it would set off red flags. Like, for example, if Friedman or Baldoni or any of the Wayfarer parties were given notice that there was this subpoena going out to a Stephanie Jones who used to work with Baldoni on his PR team, immediate red flag, check the box to object. And hey, what is this? I need a copy of it. They would have seen a copy of it. They would have tried to whittle it down, whatever. I don't know what Stephanie Jones did it. Presumably she just complied. And in the process of complying, like you were stating, catches wind that, hey, wait a minute. It sure as hell looks a lot like in these text messages that they're getting ready to prepare a defamation conspiracy lawsuit against us, breach of contract or whatever, which was going to bite into their plans to try to take over the film. They're aware. They have to look. I didn't think that it was much of an argument before, but if they know enough and are slimy enough to take advantage of a sham lawsuit to obtain other evidence that they wouldn't have otherwise obtained and use it as the basis for forming a new lawsuit, then I wouldn't put it past them. They specifically sued him for SH, and the claims are so bloody ridiculous. Like, they're so ridiculous. The thing that gives me hope is that this case, if it gets to trial, I'm assuming that it will, is going to be argued in front of a jury. And this has to make sense to them. And I'm not going to rehash the sexual harassment claims. We know what they are. But they're so ridiculous as to just not be reasonable. You put that in there, and you sue under California law, and you make a big stink about California law when you live in New York, and you have other arguments that federal law or New York should apply, except when it comes to SH, because of why? Because 47.1 offers this protection against defamation claims, which they already knew they were ramping up for, and it offers this unfair protection, which would give them an unfair advantage in the litigation. That kind of goes to conspiracy, but if you could tie that into malice somehow, then I think you have an argument to defeat the protections of 47.1. So this is what we get. December, she files the CRD. We have this sham litigation. I've been using the word prophylactic a lot, and it's never really struck me before, really today, the more that I've thought about this sham subpoena. Because I know this was your theory. It's like, oh, they filed a lawsuit because they knew that Justin was going to file a lawsuit. But they didn't just file a lawsuit. They filed a lawsuit in such a way that it would make it ultra risky to bring the specific claim that Justin was going to bring.
Yes.
You can't bring defamation under 47.1 without staring at treble damages and punitive damages if you're wrong, because they know that malice is hard to prove. So here's what I'm getting at. California courts have held that when you bring sham lawsuits for reasons other than pursuing an actual lawsuit, like, for example, we only brought this lawsuit for this explicit purpose of getting a subpoena that gave us evidence that was used as the subject of this lawsuit. And then you take that information and you because you get this information, you're aware of specifically what's coming down the pike for you. And you strategically sue under California law where you might not have otherwise done that because of the protections of 47.1 that specifically implicate one of Baldoni's expected causes of action, defamation. That's just too many coincidences to have it be innocent. It's too many coincidences to have this be above board. There's something shady going on over here. So the obvious argument is that she is deploying 47.1 protections. It's not to protect against her claims of SH. She is utilizing the protections under 47.1 prophylactically to guard against the allegations of defamation against her. Because if you take away 47.1 protections, then you don't have, obviously, the fee shifting stuff that goes on, all those other things. But, I'm not saying that it's not a slam dunk case. It's not a slam dunk case. But I'm starting to see what they did. It's still going to be very difficult to prove. I understand why people aren't jumping all over this idea. But you have to be, if you could present to a jury that, look at the nature of these sexual harassment claims. They're not serious claims. Look at the conduct. Look at all this. If you could get a jury to believe that Blake Lively's sexual harassment claims are not credible, and you tie into that the history about how did you find out about all this stuff? Where did you get this stuff? Which raises another question. I'm not sure that they're necessarily going to want to gut or make inadmissible all of the evidence that Lively obtained through that subpoena, maybe they will. And they'll just, I guess, introduce it for their own purposes. It's going to be really difficult, but I could see if they could convince a jury that the claims are so ridiculous and that this was a lawsuit that was only brought about because they found out that Justin Baldoni was gearing up for a lawsuit against Lively because they knew about Friedman's involvement all the way going back to August because they got it from this sham subpoena that they launched back in October, a couple of months before they filed this lawsuit. They had a couple of months to plan. They did the research. They figured out that 47.1 offered abnormal protections against defamation claims. They knew that that's what they were going to get sued for. And then they used it to assert, I guess, throw their weight around, thinking that Justin Baldoni was just going to bend and not fight this case and let it go because he didn't want to get canceled or whatever. And he would have figured out that his defamation claim were going to be unlikely to proceed because malice is a really high bar to meet. And therefore, you know, what this case is really about, it's about an abuse of the legal process. It's about them wasting the court's time and doing it in such a way that is just so slimy as to infuriate prospective jurors. Because guess who the jury's going to be? It's not lawyers. It's not jury. I mean, you can make the argument that 47.1 only protects, you know, certain things, and you know it only applies to malicious assertions of SH claims. Fine, but what if the entire thing was a sham? What if the only reason she filed this SH complaint was because she was trying to guard against a defamation claim, and she knew that 47.1, or not her lawyers knew that 47.1 was a pretty damn good defense against them proceeding on a defamation claim. What then? Then what you have, if you can show all those things, then what you have, if a jury decides that that's what happened, that she wasn't serious with these claims, that she used it to try to gain the upper hand in litigation, then I think that you can find malice. And I'm not saying that subpoena is like the smoking gun, but it is a very large rope that is tugging on this thing that we're chasing, which is malice. And it's giving us angles that obviously need to be developed and they need to be ferreted out through evidence. But there is a real possibility that I just disagree with this notion that this sham subpoena doesn't in any way do anything to knock down 47.1 protections. What do you think about that?
I mean, I understand about the sham. I don't think it's supposed to be here. There was not. That's the whole thing I've been trying to say. There was not supposed to be a lawsuit. So now they have to figure out how to get the way. So I don't know how it works legally.
Yeah.
But what I have been arguing in my extensive PDA, which I'm about to finish, to hopefully not. They have proof from May 17th of her extorting with people. Like they even have a text message where Melissa Nathan says in a text message that she has it written how Ryan Reynolds has called him sexual predator.
Yes.
Sorry, like all of this is written. And from May 17th, she had been extorting him for the film buy credit using this against him. And I have a feeling that maybe because they're quoting certain things, it's like it could be voice notes, it could be like voice recorded. They could, because they have been filing. This is the part like it was going to be in the PDF. And about the smear campaign, Melissa writes in the chat, it says that, oh, I'm going to send it over to Jed. I'm going to keep him to have an eye in the statistics so that we can save it as evidence. It is in a text message. So they have a proper evidence of her, like, I don't know, like playing them. So that's why they're so confident. They're not scared of the 47.1. I actually don't think they want to use this sham thing against them. I think Brian Friedman wants to go and make her like, to try her and be like, okay, say it now. and then let's see how it happens. And I think that's the whole point. And
Yeah.
I've been trying to say that people are worrying about this 47.1. It's pointless, because Blake Lively knows exactly what they have, because she has seen it in Jen Abel's phone. If she knew that, if she thought there was a smear campaign, wouldn't she have used that to buy the rights to the movie right after? You know, well, how come Ryan was saying in September, I'm going to buy, you know, I want to offer millions? They could have totally used that smear campaign. They could have used that 17-point list against them, but they couldn't. So they had to, and that's what I've been trying to say. So there's like what now, right now, the question is not how Brian Friedman can get past 47.1. He doesn't care. 47.1 doesn't stop them from still pursuing the lawsuit. It just
I think he still cares about it. He definitely cares about it. Like,
no, depending. What if that's the thing. What if they have so much proof already, and then they will discover way more?
Well, if he does, I mean, I don't know what. I mean, maybe that's true, but he definitely is not unaware of 47. I don't know how afraid of it he is. I've been arguing that I think that they're going to be able to show malice even before this sham subpoena. I'm just saying that like it paints just a more complete picture of like their entire plan. And it kind of fits into what you were saying, because they had all this stuff back in May, or they found out back in May or whatever. And then they get all of these phone records, and maybe it freaks them out a little bit.
Omar, I just want to give you a perspective. Sorry to interrupt. I am thousands of miles away, and I have figured this theory out based on 168 pages. In total, maybe like some 800. And this is, I think, the evidence that they have. And this is what they've let us see. Imagine what they have, that they're so confident.
No idea. Yeah.
So we're speculating that, oh, they're going to need more evidence, but they're showing, like, to the world, communicating that, you know, like, we have evidence, this is the story. And please don't forget that also Justin Baldoni's personality and who he is very important, because he has always said the point is not to make her, I don't know, bad or make her worse. It's just to clear his name from day one. And I would be so sad if he like accepts a half-ass apology. Like, I'll be mad.
I don't think he's going to accept an apology. I'm just no, I don't disagree with anything that you're saying. They probably do have a lot more evidence than they're letting on. Of course they do. Like, there's things that are going on in this lawsuit that we don't know about. Like, we're over here arguing about subpoenas, and then Friedman's like, this is the first I've ever heard about it, but I will pursue it to the extent of the law. Looks like they try to exploit a loophole or whatever. Is it gamesmanship? I don't know. I was thinking it more in line with what you were pointing. It's just another piece of the puzzle. It's not that they don't already have, or it's not that they're not confident in what they already have. It's just that this is kind of like a damning show or demonstration of a pattern of how they've litigated in this case, going all the way. I mean, they start with this, right? They've been extorting Baldoni for months, and then couple that with this sham lawsuit, sham subpoena, bullshit SH claims, whatever, and then he fights back with all that stuff. Coupled with all the other allegations in his first amendment complaint, Baldoni's a complaint about stuff that what Reynolds was doing, stuff that Lively's PR campaign was doing. All of it you got to put into like one big pot of malice. And then the question becomes, what can you use that for? Can we use it to knock out 47-1? Could we use it to prove conspiracy? Could we use it to prove agency? Could we use it to prove this and that? Because they're going to have to address those things at trial. They can't get around those, talking about those issues. And it might be the case that they have better evidence than they're letting on. It probably is. But this 47-1 stuff, if they could demonstrate as a talking point that Blake Lively explicitly weaponized the Me Too movement and filed basically, I don't want to call any complaint frivolous, but she basically filed a bad faith SH claim against Baldoni because she thought it was going to help against what she knew was coming. Then aside from all the other stuff where people are already mad at her, a jury is going to hate her. And when they get to trial, they're going to weaponize that. And I'm not so sure how much 47.1 is going to matter once once they prove malice. But when it comes time to figuring out what the money damages are going to be, and there's been a no, go ahead.
Can this be used like against the motion to dismiss? It's like, look, they have already done this. That's goes beyond the ethics. How can I believe she didn't do the same thing with the CRD? And and I would like to prove it. Wouldn't that allow them to get past that?
Well, do you mean like the fact that they don't want the case to be dismissed because they want to be able to prove all these other things?
No, because Blake has filed motion to dismiss, based on her allegations and the CRD complaint, whatnot. And
sure.
Says, look, this is what they're doing in a lawsuit, and this is not a complaint. Why do you think they will do for a complaint that they don't have to follow through?
You're right. And so to answer your question, I think if the judge wants them to amend their complaint, then he will allow them to do that. And maybe some of these facts ends up in the complaint as basically formulating part of the conspiracy, part of their allegations of malice and all those other things. I'm not sure if we're going to get there or not because the judge has to rule on that first. But 100% yes. But more importantly for trial, because think about it, you're going to be hearing all this stuff, like you're going to be the juror, and all of these jurors are not going to know all of the stuff that you know because only so much of it's going to come in. They're going to have like maybe a 4 to 6 week trial, and they're only going to be able to get in so much of the evidence. And you've been sitting with this case, kind of pouring back and forth through all the pleadings, and not all the evidence in the pleadings is going to make it in a trial. And
the text messages, the ones that she had been using against him, not all of them. How so?
Unless somebody admits them somehow, they're going to be admitted basically one by one. So you have to lay the foundation for things. It's possible that they admit all the text messages, but it's just not likely. Like, for example, in my trials, like I'll get like 300 pages worth of text messages. The judge is not going to read 300 pages of text messages at trial. So you have to kind of whittle that down. No jury is going to sit through 300 pages of text messages. So you kind of pick and choose what is the most important things that you want to see. And then it could all be made like you have it, like in your back pocket. Like if you weren't anticipating a text message to come in and they state something that you can refute with a text message and you have that, then you could use it to rebut certain things. But they're not just going to all willy-nilly just admit everything unless there's a reason to do it. It's just kind of the rules of trial is all.
Okay. All right.
And then the jury only gets to read like what's in the record. So all of these text messages might not get, but that's trial strategy. We're like getting way ahead of ourselves. I'm just stating.
She's not gonna go to trial. I'm just letting you know. There's no way. Like she will have to find a way. And I don't see her going to trial.
It might not be up to her. Like let's just say that worst case scenario for her lawsuit gets gutted because the judge deems inadmissible anything that they obtained or were directed to by part of this sham subpoena. Then she's going to probably try to settle, and Freeman's going to be like, no, we want a trial. And you could treat it as we want our day in court. We want the world to see what you did.
Unless you apologize and admit, I would love if they're just like, they're made to be like sat behind the table. They read their complaint and they have to explain how they lied and why. That would be so beautiful.
I want a written apology, and I want you to saying I'm a little teapot, and then wear like this little suit. And obviously, I'm kidding. I'm just saying it's not up to Blake Lively if this starts going really bad for her to just dismiss or get rid of it or settle. If Justin doesn't want to settle and Freeman don't want to settle, and he wants to bury her on the stand and let the world see and expose her for what she is, then she doesn't have much say in it. Really, she started this. So here we are. Anyway, that is a version of how you can use these sham subpoenas to attack the 47-1 stuff. It's really a tie into all this other stuff. It's a workaround attacking the SH claims as being malicious by basically stating that the SH claims were part of a larger plan conspiracy to do all of these things, and you're going to have to like frame all of that out. It might come in the form of a second amendment complaint where they just lay all that out. I don't know. But I'm just saying it's not worthless when it comes to 47. I say 47-1 just because people ask me a lot about it. Not because I don't think that you're worried about it. I'm not particularly worried about it because I believe in Justin's case. I'm just stating it is a tool. It is a weapon that Friedman is going to have in his back pocket when this goes to trial. And with that, folks, that's all I got to say about the subpoena issue. I'm about to do Family Law After Dark, and Anita is going to be making her second appearance on that show coming up. I'll be joined by Bruce and Brad and Schnitzel and the whole gang. I hope to see you guys all there. It's going to be starting in about 2 minutes over on that stream. So if y'all haven't already found it, make your way over there. Maybe I could just redirect everybody. I'll do that. Could you tell everybody about your, are you about to publish your new PDF?
Yes, I'm fine tuning some stuff I didn't like. So yeah, hopefully I don't know, in the next 10 hours it will be out. I don't know when, I don't know what US time is, but yeah, I'm trying my best to get it out today.
Yeah. Well, if it is, if you guys need to know where to find it, maybe if you post it in the links or email them, I'll pin it in the comments so people could find it.
Okay, yeah, I'll share with you. Yeah, I'll share with you.
Yeah, people are really, they want to read it. They don't want to hear me talk about it. They want to read your work. Yeah.
Thank you.
Yeah. So, look, your theory is developing. It's developing, and we're whittling it down, and we're working on it. I'm not taking credit for your theories. I just think it's a really smart way to look at this case, and I think that it speaks to a lot of the causes of action, and I think that it does Baldoni a lot of favors in whittling down some of Lively's protections, if he could prove all of that. And it's fascinating watch it all play out, because I swear to God, every single time something drops in this case, like, hey, Anita said that. I keep going back to it, which is why you're here. And so
I need an award or something. What do I get for this? To crack
Anita, the super sleuth Redditor. I don't know. We'll figure something out. We got to get you something.
Yeah. Okay.
But anyway,
all right,
folks,
I'll see you in a bit.
I'll see you in the other one. You guys are about to be redirected over there right now. We'll see you in a few. All right.